Straight ahead on Law&Crime Daily. Closing arguments in the Derek Chauvin trial as the jury deliberates the fate of the former Minneapolis officer charged in the death of George Floyd.
This wasn't policing. This was murder.
The defense firing back, reminding the jury Chauvin is presumed innocent.
This was an authorized use of force, as unattractive as it may be.
Our team coverage as protesters take to the streets as we await a verdict. Plus, the former home of a witness for the defense vandalized. Law&Crime Daily, covering court cases from coast to coast. And welcome to Law&Crime Daily, everybody. I'm Jesse Weber in our studios, along with Brian Buckmire, who's in Minneapolis covering the Derek Chauvin trial, and with us, as always, his co-host Terri Austin. Closing arguments in the trial of the former officer charged in the death of George Floyd. Prosecutors got to go first, and Brian Buckmire is here to explain the state's version of events. Brian?
Yeah, Jesse, the prosecution began their closing arguments with an impassioned argument about who George Floyd was and kind of painting the picture for the jury. Now, prosecutor Steve Schlesser married the charges with the facts of the case, leading the jury down the path to a conviction, showing what facts, no matter how small or how large they are, could fit into the definition of all three of the charges. Steve Schlesser also took the time to point out the arguments that the defense was likely to make and let the jury know why they were not something that they should be focusing on. Prosecutor Steve Schlesser told the jury that George Floyd was not a threat that day.
9 minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe. But the force was too much. He was trapped. He was trapped with the unyielding pavement underneath him, as unyielding as the men who held him down. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds, the defendant's weight on him, as he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face. With his face. A grown man crying out for his mother. A human being.
Prosecutors then reminded the jury of the testimony of their medical experts who say Floyd died due to the knee on his neck.
The experts have weighed in, and Dr. Langenfield told you that Mr. Floyd died. Dr. Baker ruled this a homicide and told you the cause and manner of death, the unlawful, the restraint and subdual by law enforcement. What they did killed him. Told you that. Dr. Tobin, remember Dr. Tobin, he told you specifically how it happened. He walked you through that, the asphyxia. Right? He told you how it happened. And the other doctors who testified, Dr. Smock, Dr. Rich, Dr. Eisenschmidt, they told you how it didn't happen. Like, it wasn't a sudden cardiac event. It wasn't a heart attack. It wasn't a drug overdose. It wasn't any of those things. Right? Dr. Tobin came back and explained it wasn't carbon monoxide and was very clear that George Floyd died as a result of a low level of oxygen. This low level of oxygen caused a brain injury and a PEA arrhythmia, which caused his heart to stop. That's not a cardiac event. It's not that his heart disease, right, that didn't cause him to die. It was the low level of oxygen. It was the asphyxia that caused him to die.
Defense attorney Eric Nelson told the jury that Derek Chauvin is presumed innocent and that the state failed to prove their case beyond a reasonable doubt.
Capricious, fanciful. Capricious doubt? Capricious means unpredictable. Fanciful. Space aliens flew in, inhabited the body of Derek Chauvin, and caused this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious.
Now, the defense also talked about that late testimony concerning George Floyd's carbon monoxide levels, addressing the state's rebuttal witness who said Floyd had 98% oxygen in his blood when he died.
You can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd have carbon monoxide in his blood because he had this high oxygen saturation. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt.
Okay, let's break it down. Terri, you heard all the evidence in the case. Do you think that the prosecution was able to tie it all together for the jury?
I think Schleicher did an excellent job tying it together. He started out humanizing George Floyd. He specifically talked about where he was born, when he was born, his mother, etc. And then he said what the last words were coming from his mouth. They were words of respect. He said, Mr. Officer, please, I can't breathe. So I definitely thought he started out well. Then he went into each of the counts and he talked about the elements of the counts. And the other tactic that he did during this closing, which I thought was extremely effective, instead of going witness by witness, he talked about the issues and he specifically named the witnesses. So in the clip we saw there where he was talking about the medical evidence, he named the doctors and he specifically said, this one told you how he died and this one told you how he didn't die.
Right.
So I thought that was effective as well.
And Brian, what did you make of the defense's argument? Did they create reasonable doubt?
I think the defense was able to sow some kind of reasonable doubt here or there. The issue that I had with their arguments that they were making is that they kind of left the answer in the air. There's this hypothetical that Eric Nelson used about the reasonable officer leaving someone in a hot car and then dying on their own of a heart attack. Yeah, great example, but Derek Chauvin's actions sound more like the individual who left someone in a hot car than someone who just simply died of a heart attack. Eric Nelson kept bringing us to a point of reasonable doubt in talking about a reasonable officer, a reasonable officer. At this point, I don't know if he's representing Derek Chauvin or a reasonable officer because he's not making the connection between the two.
All right, well, still ahead on Law and Crime Daily, protesters take to the streets to remember George Floyd. But first, how the jury's instructions could play an important role in deliberations. Our exclusive legal analysis up next. Welcome back, everybody. Before jurors in Derek Chauvin's trial heard closing arguments, the judge read instructions to them about the law. Law and Crime's Angenette Levy's here live in Minneapolis with what the judge told the jurors. Angenette?
Yeah, Jesse, jury instructions really lay out for the jurors what they are to consider when evaluating the three charges in this case, and they are very tedious and at times confusing.
The defendant does not have to prove his innocence.
Judge Peter Cahill drafted the jury instructions with input from the prosecution and the defense. The instructions are a roadmap for the jurors.
The fact that other causes contribute to the death does not relieve the defendant of criminal liability.
The medical examiner testified that George Floyd's death was a homicide caused by being restrained by police, but that Floyd had heart disease and fentanyl and methamphetamine in his system. Under the jury instructions, Chauvin could still be guilty despite those facts. Chauvin faces 3 charges. Second-degree murder is the most serious. It's an unintentional murder that happened as a result of a third-degree assault. Intent is an element of the assault.
It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act.
Chauvin also faces a third-degree murder charge, which includes acting with reckless disregard for life and conscious indifference.
A person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind, without regard for human life, but without intent to cause the death of any person.
Second-degree manslaughter is the lowest level charge, meaning the death was the result of negligence, and the person accused took actions that had the chance of causing the death. Law and crime legal analyst Gene Rossi discusses the importance of the instructions.
Whatever those instructions are, you want it very narrow so that when the prosecution tries to make their closing and rebuttal, they have a very thin lane. And you don't want them to have any broad brush arguments that they can make.
Now, the jury instructions also include language about being aided and abetted by others in the commission of these crimes. That was added since there were 3 other officers involved in this incident. Jesse?
Terry, if the judge explains the law, then why does the prosecution explain it again to the jury?
And I'm sure the jury is thinking the same thing. The reason is because the prosecution has to tie in the law to the facts. So, for instance, this second-degree unintentional murder while committing an assault. The judge defined what an assault is. He said there's bodily injury. What Steve Schlesser did was he explained bodily injury includes, for instance, loss of consciousness. And he actually showed a picture of George Floyd when he was losing consciousness and when he had the scrapes. So he made that connection between the assault and what actually happened. And I think he did a great job.
Now, Angenette, it's my understanding that the judge included an instruction to the jury about George Floyd's drug use. Am I right?
Yeah, that's correct, Jesse. And he discussed that this morning, in the morning, during the morning session of the opening statements, before the opening statements even began. And he said that the drug use, they are not to consider that when assessing George Floyd's character. That is not what this is about and why it was presented in court. This is about looking at the condition of George Floyd during the arrest, before the arrest, and about what may have caused his death in the jury's mind. So that is why there's to look at the drug use in this case.
Look, jury instructions, so important. They are a guide map, a roadmap for this jury. The question, of course, is, do they actually follow it in the deliberations? That's something we will not know, but you hopefully think that they will. At the end of the day, the jury are human beings, and it's difficult to know what is guiding them. All right, coming up on Law and Crime Daily, a deeper dive into closing arguments by the state and defense in the Derek Chauvin trial. Plus, the former house of a defense witness targeted. The message vandals left after the break. As the Derek Chauvin trial winds down inside the courtroom, people have been demonstrating outside in the streets. Law and Crime's Kim Johnson is in Minneapolis and has the latest. Kim?
Hi, Jesse. Yeah, as the end of the Derek Chauvin trial draws closer, tensions continue to build and grow in and around Minneapolis. Thousands of uniformed and armed National Guard men and women have been patrolling streets and neighborhoods in numbers that I've never seen before, not even close. This has always been part of the plan, though, as we approach the verdict. But law enforcement and the Guard have really ramped up their public presence after last week's deadly shooting of an unarmed black man by a police officer during a traffic stop in the town just right next over. Now, protests have gone on 8 nights now after the shooting, sometimes turning violent with protesters hurling objects at police. That has resulted in police using tear gas and rubber bullets to disperse crowds still lingering after nightly curfews. The chief of the Minnesota State Patrol knows more protests are possible after a verdict in the Chauvin trial and has this message for those wanting to demonstrate their First Amendment rights.
We want people to leave. Like, we don't want to arrest people. And I think that can sometimes be confused. Like, the goal of law enforcement is not every night to see how many people we can arrest as part of Operation Safety Net. Our goal is to plead and ask and direct and help people understand how not to get arrested by listening to our simple advice.
Now, also over the weekend, vandalism in other parts of the country. In light of what's happening in Minnesota, vandals threw a pig's head at the one-time home of a former California police officer who was a defense witness in the Chauvin trial. The house where Barry Broad used to live was smeared with pig's blood. Police say he was falsely targeted over his testimony that Chauvin's use of force was justified. But here in Minneapolis, storefronts continue to be boarded up by the hour. City schools are preparing to close completely this week out of safety precautions. And the law enforcement and military presence is so thick here in Minneapolis. I had one person tell me they feel like they are in a movie. It just seems surreal of what's happening. I can tell you, though, it's really only a matter of time before the streets of surrounding the courthouse are going to be filled with demonstrators, as we know that there are rallies being planned as we speak, as we approach verdict time. Jesse.
Wow, it's pretty incredible. Kim, just to clarify, what are the protesters calling for when it comes to the verdict?
Well, I have been covering this trial since day one and been really in tune with protesters in the community and what they've been asking for really since George Floyd died on May 25th, 2020. And mostly they want Derek Chauvin found guilty on all three charges, not just one, not just two, but they want a guilty verdict on all three, on the second-degree murder, the third-degree murder, and the second-degree manslaughter as well. They have said on Facebook that they plan widespread protests to take to the streets if they don't get a guilty verdict on all three charges.
Pretty incredible. Kim Johnson, thank you so much. When we come back, more from closing arguments in the Derek Chauvin trial. Which side will the jury believe? Up next. Back now to our coverage of closing arguments in the Derek Chauvin trial. Prosecutors say the former officer is guilty of all three charges against him.
How can you justify the continued force on this man when he has no pulse? No pulse. The restraint continued grinding and twisting and pushing him down and crushing the very life out of him. It wasn't too late. He could have rolled him over, performed CPR. No, he continued. Past the point of finding a pulse, past the point where the ambulance arrives, past the point where the EMTs get out. This was a counterfeit $20 bill, allegedly. What is going on? Why hold him that long, past that point, past that line that was crossed? No. Unreasonable force. Not proportional, excessive. It violated policy, it violated the law, it violated everything that the Minneapolis Police Department stood for. It is not lawful.
Defense attorney Eric Nelson, though, told the jury that Chauvin's use of force was justified and that he was simply following police policy.
Simply because someone isn't stabbing you, or punching you, or shooting at you, it doesn't mean that you can't use force. And that is specifically in the Minneapolis Police Department policy on the non-deadly use of force that we've looked at a couple of times. The use of force is an incredibly difficult analysis. You can't limit it to 9 minutes and 29 seconds. It started 17 minutes before that 9 minutes and 29 seconds. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt.
Okay, let's get some perspective. Brian, what sort of reaction are you seeing, if any, from the jury during closing arguments?
So from what we're getting from the pool report notes, the jury is really paying attention to those definitions. When they see a lot of the graphics that are used by both sides, the defense and the prosecution, giving the definition of use of force, giving the definition or the charts that we're seeing of various incidents, we're really seeing them taking notes on that. Not so much on just kind of the more ad-lib arguments or just kind of the reactions from the prosecution or the defense. So it's interesting to see what they're focusing on and what they're not so much based on the writing of notes.
Terri, let's focus on the defense for a second. Eric Nelson spent a great deal of time setting the scene and trying to get the jury to see the totality of the circumstances. Was that right, or was it a little excessive for the jury? Was it too much?
I think it was way too much. He went on way too long. Look, he talked about legal issues that I think the jury already knows about, the presumption of innocence beyond a reasonable doubt. He talked about this perspective versus perception. When he finally began to talk about the actual facts here, he discussed what happened on the scene from 8:02 when the call first came in to his death, 8:25, that critical moment. And basically, he talked too long about what happened beforehand, because no one really is putting in dispute the fact that the force was reasonable beforehand. So I think that it was not relevant, and I think he spent way too long, and I think the jury wasn't happy.
All right, well, we'll wait and see what the jury thinks. Terri, Brian, thank you so much. And everyone out there, thanks for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.